As soon as we, all right, here we go. The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court. Hear ye, hear ye, hear ye. All persons having business.
Good afternoon. Welcome to the current argument on the Kansas Supreme Court. I'd like to welcome counsel and to all of those of you who are watching via the video live feed. For anyone who hasn't been watching our arguments this week, we do have several faces that are new or different than typical on the bench. First of all, we are welcoming this week our newest colleague, Justice KJ Wall, sitting on his first docket. In addition, because of the impending retirement of Justice Carol Beyer, she is not sitting with us this week. We have instead the senior judge assigned to our court, Senior Judge Mike Ward, who has been sitting with us since March as in that position. Before that, he was a district judge in the 13th Judicial District. And then on this case today, Justice Dan Biles has recused from hearing this matter. And so we are very pleased to have the able assistance of Chief Judge Grant Bannister. Since 2019, Chief Judge Bannister has served as the Chief Judge of the 21st Judicial District, which is made up of Riley and Clay counties. He was appointed to the bench there in 2016. He, of course, leaves a very busy docket as he gives us time to prepare for, hear, and cover this case with the court and continue through our deliberation process until a decision is filed. So, Judge Bannister, thank you very much for your willingness to do that. With that, counsel, I'll turn to you, and as we are anxious and looking forward to your arguments. So I will ask the clerk of the court to please call this afternoon's case. Mr. Shima.
Thank you, Your Honor. May it please the court. The 1:30 p.m. docket for Tuesday, September 15th, 2020 consists of one case. Appeal number 117839, Building Erection Services Company Incorporated versus Walton Construction Incorporated et al., Johnson County briefs both sides. The argument is set for 20 minutes each side. The petitioner, Walton Construction, has reserved 3 minutes rebuttal time. We are ready to proceed, Your Honor.
Thank you, Mr. Shima. Counsel, would you please state your appearances and identify the party you are representing?
Good afternoon, Your Honors. I'm Danny Webb. I'm with Horn, Aylward, and Bandy in Kansas City, and I represent the appellee Walton Construction Company, Inc.
Good afternoon, Your Honors. This is R. Scott Beeler, B-E-E-L-E-R, of the firm Lathrop GPM. Also with me, Carrie E. Jozerand and Kurt F. Brock, both of them on the briefs with me. We are here representing Building Erection Services. Mr. William Miller, representing that company, is also present here in the conference room. We are ready for argument. Thank you.
Thank you, counsel. In this case, as the case appears before us, we are here on the petition for review of the appellee, who will begin our arguments today. Mr. Webb.
Thank you, Your Honors, and may it please the court. We appreciate the opportunity to be here, even though it's remotely. It's nice to see everybody, and we appreciate the court's time in taking this case. It's an important case to the parties here. This case comes to you, as you said, Your Honor, on review from my client, the general contractor for the construction renovation of the press box at the KU Memorial Stadium. It also comes to you following 3 hearings at the trial court level and 3 hearings at the appellate court level, all of which affirmed the obligation of BESCO, the appellant in this case, to indemnify Walton and the University of Kansas for costs incurred in correcting BESCO's defective work at the press box. We're asking this court today to affirm the district court's findings in favor of Walton on its indemnification claims against its subcontractor, and asking this court to reverse the interim appellate decision that took away all damages on all claims, even though BESCO's liability to Walton was uncontroverted throughout the proceedings. At the outset, I would ask the court to be mindful of the standard of review that brings us here, and the ultimate issue in this case, which pivots on the question of whether substantial, competent evidence supported and supports the district court's findings. We know that that standard means that if there is legal and relevant evidence that a reasonable person could accept to support the district court's conclusion, it should be affirmed. We know that the Court of Appeals and this court is not burdened to reweigh the evidence or to make credibility determinations or to resolve conflicts in the evidence. All that is done at the district court level. And the district court on this standard of review is entitled to great deference in its factual findings. This court is not called on to redetermine questions of fact, nor was the appellate panel required to do so. There are essentially here 4 elements of damages, 3 of which are before you on review. The first element of damages I'll touch on briefly is uncontroverted. And that is after BESCO used the improper construction drawings and installed the wrong fasteners to anchor the glass press box system to the press box structure at KU, the university undertook a remediation plan to fix that work. When those anchor problems, those structural problems were discovered, what prior had been a water infiltration issue took on new light, new meaning, and much more importance, because the structural integrity of the press box itself was in peril. As a result, the KU officials, architects, engineers, and design team put together a protocol to remediate those defective fasteners that BESCO had installed. And as part of that work, which was undertaken by a contractor called Farrell actually physically replaced and repaired those anchors at a cost of a little bit more than $50,000. That's not in dispute in this case. I mention it because BESCO in its briefs has indicated that that's the starting point at which BESCO's indemnification begins. From that point, the parties and the courts have taken different paths. The district court found that there were responsibilities owed by BESCO to Walton to replace the glass panel system at the press box and to remove and replace the metal panels at the press box as well. And the district court found, based on the evidence before it, which we will explore in a moment, that BESCO was responsible for 50% of the remediation cost of the glass removal and replacement, and 85% of the cost to remove the metal panels and to replace those to access the anchors.
Mr. Webb.
Yes, Your Honor.
I understand that the pivotal question here is, out of the total remediation project, how do we allocate the responsible costs, or the costs that are responsible to BESCO under the contract versus those that are outside? But what was the mandate in BESCO 2?
The mandate in BESCO 2 was for the district court to undertake additional findings to make that apportionment, to make that allocation. And in fact,
that was BESCO 1, but was BESCO 2 more specific in rejecting the 50-50 allocation after the initial remand?
BESCO 2 did reject the 50-50, but as the district court noted in evaluating what the mandate was, the district court was left with very little guidance on exactly what that meant. In fact, as the district court said, does that mean it's 49-51? Does that mean it's 10-90? And the district court struggled with that, as did the parties. So what the district court did was went back and evaluated the evidence that had been presented to it, including the evidence of the KU officials who were responsible for overseeing the remediation, and evaluated that evidence, whereby the university's primary witness, Robert Rombach, determined that the, and I'm quoting, vast majority, Vast majority of the remediation costs were incurred by the University of Kansas to address the fastener issues. That is the ultimate issue.
Why wasn't that assessment made in the previous assessment of the remediation costs? I mean, it took 3 times for the district court to reach that conclusion that the vast majority was attributed to BESCO, or why did it take? It just seems like the assessment of the apportionment anyway jumped around some. Why is that?
I don't know why that is, because the evidence, at least with regard to BESCO 2 and BESCO 3, the testimony and the evidence was consistent that the vast majority of those costs were attributable to BESCO to remediate the fasteners. That was both in testimony and in documentary evidence before the district court. And as indicated, I think the district court struggled a bit, evaluated this extensively, and ultimately came to the conclusion that the evidence supported the 50-50 apportionment of the glass cost, which is obviously less than the vast majority, and also 85% of the remediation costs associated with the metal panels. And to further support the district court's findings, he determined, and the evidence supported the conclusions, that the metal panels and the glass panels had to be removed and replaced in order to find and investigate and ultimately replace the defective fasteners that were part of BESCO's scope of work.
And how, under the BESCO 2 mandate, did the judge have the authority or the discretion to go above the 50% to the 85 on the, even on though it was the metal? Or did the mandate limit the judge in some way?
No, I don't think the mandate limited the judge, Your Honor, because it wasn't specific in terms of, is 50-50 the floor? Is 50-50 just the wrong answer? And the court's opinions in that regard are reflected in one of the transcripts, where he specifically says, I think BESCO 2 has said that it's not 50-50, but it doesn't say what it is. It says what the Court of Appeals has said, and they have said it's not 50-50, but they didn't say it should be 49-51-10-90. And he said, what the appellate panel in BESCO 2 has given me is that I am to review what's already been presented and make a determination, period, and it's not 50-50. Under the mandate rule and the law of the case rules that Your Honor referred to, it's imperative that justice be served and that justice reflect what the evidence is. And the court below, and certainly this court as the highest court in the state of Kansas, has the ability to get to the right result based on the evidence to make sure that the conclusion is not clearly erroneous or manifestly unjust. And that, I would contend, is exactly what the district court did by reevaluating the testimony and the evidence under which those remediation costs were the responsibility of BESCO.
But if we were to construe BESCO 2 as a rejection of an allocation between those two buckets of 50-50 or more, then your failure to petition for review of BESCO 2 really then waives your current challenge, does it not? Now, I know you would dispute that construction, but is that where we're left?
I understand that argument, and you're right, Judge. I would dispute that contention, because ultimately the goal is to get to the right answer. And if the district court, as the district court indicated, was confused about what that mandate was, I think the district court did the very best it could to interpret it and to carry out justice. And in front of us today, to be in this court We're here so this court can specifically address whether the findings and conclusions are supported by the evidence. And if so, the BESCO 3 opinion would be clearly erroneous and would result in manifest injustice under the evidence of the clear evidence that BESCO was primarily responsible for the remediation costs under the testimony that the district court had before it.
I'm not sure if I understand if you believe that we have a clean slate. I mean, from some of the comments that you made, are we bound, even if we feel like there were errors in the Court of Appeals that led to the BESCO 2 mandate? Is it your view that we can reevaluate those errors at this point?
Yes, it is, Your Honor. Under the Supreme Court of Kansas decisions and the United States Supreme Court decisions that we've cited in our brief, including the Pepper case and the Arizona versus California case, the Pearson versus City of Topeka cases, this court, obviously, as you know better than anybody, is the court of last resort in the state of Kansas. And it is incumbent upon this court to make sure that justice is carried out. If the Court of Appeals in BESCO 3, as we contend, got to the wrong result, then that's the prerogative of this court to review and make sure that justice is carried out.
What is the effect then of the fact that BESCO 2 was not appealed to this court?
I'm sorry, Your Honor?
If you're not bound by the mandate of BESCO 2, what is the effect then of the fact that you did not appeal that decision to this court?
Well, I think since the court is hearing this review, we are here for the purposes of reviewing not only the BESCO 3 decision, but also the district court's attempt to carry out the mandate that flowed from BESCO, from the BESCO decisions.
So you agree that the lower court was bound by the mandate in BESCO 2?
I agree that the district court was bound to carry out that mandate as best it could based on how the mandate was articulated. And I think part of the frustration that the district court expressed in this case was confusion over exactly what the mandate was and what it required or what it didn't require the district court to do. And so the district court, I believe, did its level best to get to the right answer based on the weight of the evidence that it had before it. I would also mention here that part of the BESCO 3 criticism appears to relate to, has Walton carried its burden of proof? And it's interesting that BESCO 2 specifically addressed that and said that, in speaking of the Court of Appeals, this court did not rule that Walton had failed to meet its burden of proof on the damages element of its indemnification claim. Throughout this case, at both the district court level and at the appellate court level, BESCO's obligation to indemnify Walton has not wavered. That's always been the case. The only issue before the district court with which the appellate court panels have disagreed is how much, what's the level of damages? And we keep coming back to the testimony before the district court that supports the findings of the vast majority of those remediation costs being apportioned to BESCO to fix BESCO's defective work in the first instance. And so when we focus on the pivotal issue of, are the district court's findings supported by substantial competent evidence in the record? The answer to that is absolutely, they are. They are supported by the vast majority of remediation costs being attributed to BESCO as the witnesses and the documents before the district court determined.
Counsel, I'd like to ask you something that's related to that, and it has to do with the Court of Appeals decision not to remand this case for a fourth time. And as I read the Court of Appeals opinion, highly summarized, they said, you had 3 shots at the apple, you don't get a fourth. And they cite some case law from our court that suggests they can do that. My question is, what is our standard of review of that decision by the Court of Appeals, in your opinion?
In my opinion, you have the unlimited review of that decision. I think when we're looking at the district court level's decision, we're looking at whether the district court abused its discretion in finding for Walton and against Besco on the indemnification provisions and the attorney's fee provisions.
And I guess my quick follow-up would be just to probe a little bit further. Why wouldn't our review of the Court of Appeals exercise of its discretion not to remand also be sort of an abuse of appellate discretion standard?
I guess in some senses that would be possible. However, we keep coming back to manifest injustice and whether the findings and the conclusions by the Court of Appeals in your question, Your Honor, or by the district court are clearly erroneous. And based on the record before the district court and the record that made its way to the appellate court, we contend that a finding that Walton is entitled to nothing as a result of its subcontractor's failure to perform its work is in fact manifestly unjust and clearly erroneous. I see that my time is out. I hope I've answered your question. If I haven't, I'm happy to address it again in rebuttal.
Chief Justice.
Are there other questions?
Just briefly, I'm sorry we didn't allow you the time to get to it, but I was looking for the record evidence as to any allocation on the cost and attorney fees award. I don't see that in any of the successive hearings or proceedings.
I think you're right, Your Honor. I think that the trial judge made those apportionments and determinations at each stage of the trial proceedings, beginning in April of 2008, I believe it was, when the court took evidence and heard from the parties on the initial application for attorney's fees, where the trial judge granted the majority of the attorney's fees and costs that had been incurred by the University of Kansas and Walton to that point, but didn't grant everything. And then successive hearings on the follow-on applications for attorney's fees. Those do appear in the record, Your Honor.
But in terms of allocating it based on the scope of work of Besco, or is that required?
I think it's a slightly different measure for the attorney's fees than it is for the repair costs, although the attorney's fees all flow out of the indemnification provision, which is related to the work that Besco did. And I would come back to the fact, Your Honor, that throughout the course of all of the proceedings, Besco's liability has been affirmed. And it's one of the reasons why I wanted to mention the actual cost of repairing the physical anchors, that $50,841 cost that was clearly Besco's responsibility, gives rise to the attorney's fees and the costs as well. If there are other questions, I'd be happy to address them. Otherwise, I'll reserve my, I guess, remaining time for rebuttal.
All right. I don't see any further questions. Thank you, counsel.
Thank you, Your Honors.
Mr. Beeler.
Thank you, Your Honor, and good afternoon to all members of the court and to counsel. I share his comments that we thank you for taking your valuable time today to hear our case. And I want to jump right into some of the questions that were being asked by the court. Basically, there was a question of when BESCO 2 said substantial competent evidence does not support a 50-50 allocation. I believe it is a great stretch to make any interpretation of that there could be a greater allocation. Nothing could be further from the truth. What the court was saying when you read BESCO 1 and BESCO 2 and BESCO 3 all together was that this particular claimant, Walton Construction, simply swung for the fences every time and ignored the instructions and the mandates of the court to go back and present evidence that would appropriately and per the evidence allocate fault to BESCO for its limited scope of work. The $50,000 number was never claimed in this case. If you look at the rulings in BESCO 2, the court went probably beyond where it had to go to strongly urge and suggest Walton that they go back and present that evidence, the actual repair cost for the fasteners done by BESCO, as a damage element in the case. Once again, when the matter went back, there was no additional evidence presented. There was no additional record. They simply went back and said, you are the friendly court here, Judge. You are the district court who has granted us an award above anything we've proven in this case, and we want to come back to you again. That's why there was no appeal of BESCO 2. They knew what they would be headed for. Instead, they went back to that friendly forum and asked for the same amount of damages again. The court asked and brought up the vast majority comment. That's not a comment made by counsel to the court asking for damages. Once again, they asked for 100%, not 50, not 40, not the 10 or the 90 referred to by counsel. I said not 100. Yes, 100. That's all they asked for, ever. Similar to the court's question about fees. There's never been a fee allocation argument made here for $50,000 worth of damage for $5,000, which is, by the way, what BESCO thought it would take to fix those fasteners, a de minimis number. But there's been no allocation, ever. Just simply, here's all of our fees. And as you read BESCO 3, you will see the references to fees, even including from a year prior to any claim or notice being made for BESCO at all, including all of the fees between Walton and its actual client, the University of Kansas.
Mr. Beeler.
I'm joking. Pardon me.
I'm sorry, I didn't mean to cut you off, but before you got too far down that path, if we agree with you on the interpretation of BESCO 2, that it was a rejection of the 50-50 split, do you agree with Mr. Webb that there's, despite an apparent waiver?
In order to revisit law of the case, you have to have either new evidence through a new trial, you have to have a change in a statute or a case, or you have to have exhibited manifest injustice, which is then appealed to the higher court. And in those cases, the higher court then has limited ability to step in and change what is law of the case. The failure to make that appeal, first of all, is fatal. No ifs, ands, or buts about it. Second is manifest injustice. Judge Perrin said in the BESCO 3 decision, why should we give them a fourth chance when we have spelled it out so clearly for them on 3 prior opportunities? How is it manifest injustice if they have elected from a trial strategy standpoint to do the same thing over and over again? It's like the definition of insanity. That we have not 1, not 2, but 3 different appellate panels who have reached the same conclusions, that they failed to meet their burden of proof despite specific mandates and opportunities to do so. And that carries over directly to the attorney's fees commentary as well. So I do not agree, Your Honor.
Counsel,
Yes,
quick,
Justice DeGaulle.
yeah, quick follow-up. Thank you. I certainly understand your position with respect to the mandate rule, i.e. that the Judge Moriarty's decision to award in excess of 50% violated the mandate rule, but it sounds to me like you are framing that as a failure of proof. And that's where I guess you lose me. Why is, as you characterized it, Walton's swinging for the fences? Why is that a failure of proof? In other words, if I try to prove 100% of my case, that doesn't necessarily mean that I didn't prove 25% of my case.
If the evidence was in the record to support that statement, I would have to agree. But you may recall that, and it's stated in, I believe, BESCO 3, there are so many here, I lose track, but I believe it was stated that counsel was very candid with the court when asked at appellate argument, is there record to support any specific allocation of damages against BESCO? And counsel said no. He said, I believe we get close to it in a few places, but no. That was before one of the remands. They've never gotten close to it. They've never even begun to argue it, Judge. So basically what counsel is saying when he says the goal is to get the right answer, I beg to differ. The goal here is to see if the plaintiff claimant met their burden of proof in this sense. As we all know, in order to recover in a case, you must prove liability. What they have proved is that there wasn't a restricted and limited indemnification clause that limited any damages to a specifically proved number that attached to the building erection services negligence in their work.
You're saying
Second element, of course, is, pardon me, Judge, second element is damages. And what I'm saying is, despite the specific instructions from 3 different appellate panels, they refused to ever allocate those damages and instead pushed that BESCO was responsible for the entire 100% of the cost. So in the end, pardon me for using this example, it was a dart throwing exercise. Pick a number, throw a dart. Maybe it's over 50%. If so, pick that number. That's not substantial competent evidence of the percentage of fault that is attributable to BESCO for their limited scope of work. It is pure rank speculation. And that has been our argument 3 times in a row. And as I will advise you, the very first time I did say to the court, it's been a long time since I was in law school. I've laughed in this case and say when it started, I had hair and a full beard. But the point is, I used to hear that you got one bite at the trial apple. You better present the best case you can, because if you try to claim damages that aren't yours and an appellate court reverses, you're not likely to get a second bite at the apple to go back and say, whoops, now let me give you the real damage number. That's what's happened here.
On that point,
Yes,
I'll
sir.
ask the same question I asked your opposing counsel. What standard of review would you have us apply to the Court of Appeals decision in BESCO 3 to end the case and not remand it?
Certainly an appellate court has multiple remedies available to it, from affirmation to affirming in part, reversing in part, remanding for additional proceedings, remanding with an order that the mandate be entered. They have a multitude of things they can do. One of those is to, as they did here, end the case and say you have failed to follow the mandate 3 different times. Your case is over. I believe that's an abuse of discretion standard, no question about that. And nor did I see claimed, by the way, by the appellants in this case, that there is any manifest injustice by that. And I think they would have needed to make that claim. But moreover, I believe it is an abuse of discretion, and there certainly has been nothing to show that 4 bites at the apple is an abuse of discretion.
Is it, and if we accept that that is our standard of review, would it be an abuse of discretion to punish a party for a judge's error? In other words, it would be the judge that failed to to abide by the mandate, not the party. Is that would that be an abuse of discretion?
I would need to reframe, Justice, while I certainly agree that this is a judge who was trying its level best not to effectuate the mandate, but rather to get to a result that this court seemed to want to have. But so did this plaintiff. They are the ones who swung for the fence. If they had gone back, as BESCO 2 suggested they do, and limit their claim to those damages they could actually attribute to BESCO and set those forward, and remember, Judge Moriarty gave them another trial bite. Bring in any evidence you want. So again, it was strategic on the part of this claimant to try and get this huge number, blaming BESCO, which again was our first argument, for the sins of others that actually caused all that water infiltration and all those problems. And them gone, let's go after the remaining guy. And basically, again, they allowed this court to make that error, if you will, by the fact that they chose that trial strategy. Court couldn't have made the error if that wasn't the claim. I keep hearing the manifest injustice, get it right. That is the part that is difficult for me. BESCO, which is building erection services, has been put through the ringer for 12 years. Simply, they won the initial part of this case. They made a claim for damages that they weren't paid, like $12,000, $15,000. Not an issue in this case, but they've been hanging on through all of the rest of this time, simply asking appellate courts who strike down the claim every single time, 100%, including all fees, to end the case. And over in BESCO 1, I said, don't give them another bite at the apple. This was their choice to seek this level of damage, which they had no right to have. BESCO 2, and by the way, I also said they shouldn't be allowed to add to the trial record to go back and fix their mistakes, not the trial courts, but theirs. That was overruled, and BESCO 2 said that was within the discretion of the court to allow that additional evidence. So be it. So BESCO 2 then comes to another decision at the trial court level, unsupported by the evidence, goes up on appeal, completely reversed and remanded, including fees, with the mandates that everyone has discussed here today. No new record at that point, still a claimant who refuses to allocate the damages, and we end up with not only a similar decision to the BESCO 2, which was completely reversed, but an added percentage of an additional 35%, even though the court specifically said 50% was not supported by the record. That to me is a pretty bold attempt. And I believe the BESCO 3 court recognized that and said, enough is enough. BESCO, you have been put through the ringer. If there's any manifest injustice, it is to you, and that's why this case is over. And there shouldn't be any fees associated with it. And I do urge the court to look strongly at that BESCO 3 decision, where you will see examples made of some of the fees that are being requested in this case and how utterly unattached to any BESCO wrongdoing they are, and still unallocated. So I don't want to speak for the sake of speaking. Those are our points. We feel very strongly that this case is over and should be over. We feel very strongly that the litigant in this case made its own strategic decisions for the damages it sought in BESCO 1. It then made similar decisions for BESCO 2. It ignored the mandates of the 2 prior courts. I think it may not have been said here today, but BESCO 1 was petitioned to this high court, and that petition was denied. BESCO 2, they made a strategic election not to petition. And BESCO 3 comes along, and they get an even stronger result, maybe that they didn't anticipate, Maybe they thought they would get to go back again, but the court said no. And then they appealed to you, basically on an equitable basis, saying, we're trying to get the right answer. These are the people who refuse to give you the right answer and refuse to give it to Mr. Miller and his company and to the district court and to the appellate courts below. We don't think that conduct, those decisions, those strategies should be rewarded. We ask that you affirm the Court of Appeals. I'm certainly available and happy to answer any questions the court may have.
Mr. Beeler, does the indemnity
Yes, Judge.
provision and the prior holdings in BESCO 2 require the attorney fees awarded arise from BESCO's scope of work?
Absolutely.
Or does a different
Absolutely.
standard apply, as Mr. Webb suggested?
No, it is specific that they are, and it's so stated, and that's part of the record, that they are to arise from the scope of work.
And that's from the plain language of the indemnity provision too. Is that your position?
Yes, sir, it is.
Caused by, in whole or in part, by the negligent acts or omissions?
Correct. And I would add that BESCO 2, the unappealed decision, has that as a finding and a mandate in it.
But is it also accurate to say, and hopefully this is my last question, that the record does include evidence of damages that are attributable to BESCO's scope of work, such as Farrell's remediation work on the fastener issue?
The general record itself refers to that number. The plaintiff or the appellant claimant here never sought that as their element of damage. You would have to discern that as a court and say, well, there's at least this, when that wasn't the claim. So none of the courts have been reviewing that. They've been reviewing the district court's finding of something much greater, which frankly has no real relationship to that Farrell number at all.
Let's say the district court did exactly what you just recited. Ignore Walton's arguments and look at the record and say, well, I see this number at least. I can make that apportionment. Would that, in your view, would that be supported by substantial competent evidence?
No.
Why not?
The Farrell bid itself had a number of scope issues in it that were unrelated to BESCO. That 50 number is the total. There was no allocation along the way as to what was BESCO's and what was not. So once again, it would be make work, if you will, by any court, looking at the existing record that, as counsel even indicated to the prior appellate court, does not allocate these numbers. It's making it up from thin air, Judge. There's simply no claim that that number, that percentage is BESCO's. That never happened.
How would you prove up an allocation?
Shouldn't
Other
that be a
than
question
just
for?
making arguments. I mean, I guess that's one interesting thing that I'm sort of hung up on here. We keep talking about this allocation and what the parties argued the allocation should be, but how would you produce evidence of a certain number?
Well, I certainly would start with the actual repair of the fasteners. And if that's the cost of the screws or the wood or whatever it would have been, an item by item basis of what did it take to simply put in longer screws.
But that's not an allocation, is it?
No, I'm sorry. I thought you said how to prove it up.
How do you prove the division, the percent?
Well, and that's what I understand your question, I think, Judge. And it's an A over B situation. We know what the total is. And if you can prove up what BESCO's cost would have been to fix just its scope, you can do the math and you come to a percentage allocation. That's where, again, not Besco, but Walton refused to do that despite 3 different courts telling them to do it. The court needed to know, what are those numbers? They were never provided. And instead, as I said, swing for the fence. We want the whole. And it's up to you, they're almost saying, it's up to you to go back and figure out what equitably we should have, because we're not going to tell you what the real number is. And that's the manifest injustice to the Besco world, is that decision they made. I hope that answers the justice's question. My time is up. Thank you very much, Chief. I appreciate it.
Thank you. Any other questions for council? Mr. Webb, you reserve 3 minutes.
Thank you, Your Honors. I'd like to start where that line of questioning just left off, to highlight for the court what the record actually reflects with regard to the evidence of Besco's responsibility. And I would call Your Honor's attention to Exhibit 702, and I believe that appears in the Record on Appeal in Volume 41. I would also call your attention, well, I'll tell you what it says. This is the document on which Mr. Rombach testified for apportioning the repair costs to Besco. And he testified, and I believe the Record on Appeal for the testimony portion of this is Volume 16, where he says, after doing a number of calculations and apportionments himself of taking things out of scope that weren't Besco's responsibility, he says, Besco's responsibility for the remediation costs includes its $390,138 for the glass and glazing work, together with Farrell's self-performed work on the structural protocol in the amount of $50,481. The total of those figures, he says, is $440,619. He then goes through an A over B mathematical equation of the overhead that should be attributed to Besco, and concludes that when Besco's share of the overhead is added to its share of the remediation contract, Besco's total responsibility is at least $480,078. That's for the glass and the fastener removal. That's the evidence the trial court had. In addition to that, Mr. Rombach testified that the vast majority of all of the remediation costs, which includes the panel replacement, are Besco's responsibility because those panels had to be removed to access the fasteners. And on that point, I think it's important to note that the Besco 3 panel, which was critical of that 85% apportionment, said, well, geez, majority means anything between 51% and 99%. I think at that point, the Besco 3 opinion is saying we need a number, and the number that the trial court came up with was 85% on that, which of course is vast majority of the remediation costs for the panels. I see my time is winding down. I'm happy to address any other points. I think it's clear that the record in this case contains substantial competent evidence to support the district court's findings and allocations of Besco's indemnification obligation to Walton. We would ask that this court not reward Walton, but compensate Walton for what it and the university spent to overcome Besco's deficient work as outlined in the record. And we ask that you affirm the district court's decisions and reverse the intermediate appellate panel's decision that took all of those damages away despite findings of Besco's liability.
Counsel, did Walton ever make any attempt to prove that their claims were caused in whole or in part by the water infiltration problem?
there is no correlation in the record between the anchor problems and the water infiltration. The water infiltration problems led to the discovery of the anchor problems. And the anchor problems then took over, and that's where the emergency protocol was developed and went forward. The costs that we're seeking in this case and the costs that Mr. Rombach testified to are all tied to the fastener remediation, not to the water infiltration. And he says that by saying the vast majority of the remediation costs were incurred by the University of Kansas to address the fastener issues.
Thank you.
When you say affirm the decisions of the district court, which decisions are you referring to? All the decisions?
Yeah.
ESCO 2, which ones?
The most recent apportionment of an allocation of fault that led to this this appeal. So the journal entries and memorandum decision that supported it, Your Honor.
Thank you.
Any other questions? Thank you to both counsel for your arguments today. The court will take this matter under advisement, and court will be in recess until 9 a.m. tomorrow morning. Thank you.
Thank you, Your Honors.
Thank you, Your Honors.